Death is the one absolute certainty in life, and when a person dies, they leave behind a collection of material possessions that must go somewhere. The law of succession is the branch of private law that handles this transition. It provides the legal answer to exactly who gets what from a deceased person's estate. This estate follows one of three pathways: testate, intestate, or succession by contract. The testate pathway applies when a valid will allows you to choose your heirs. Without a will, the estate follows the intestate pathway, where default rules dictate distribution. The process is strictly formal. An executor must liquidate and distribute the assets under the direct oversight of the Master of the High Court. While these mechanics appear straightforward, applying them in South Africa requires navigating a mixed legal system with a unique historical burden. For centuries, colonial powers imposed Roman Dutch and English common law as the primary frameworks for property and inheritance. This Western system existed alongside indigenous African customary law, which continued to govern local communities despite being marginalized by the colonial state. The Black Administration Act of 1927 turned this divide into law. It severely restricted how indigenous citizens could leave their property, often forcing estates to devolve according to state-defined customary rules rather than the owner's wishes. This created a fractured legal landscape, where a single nation governed death using two culturally opposed philosophies. Common law succession is built on the individualistic transfer of wealth. This focus is encoded in the Wills Act. It grants you freedom of testation, the near absolute right to leave your assets to anyone you choose, provided you follow the strict written formalities shown here. Even the Intestate Succession Act follows this logic. Without a will, it divides an estate using a mathematical hierarchy of spouses and blood relatives. Historical African customary law operates differently. In this tradition, the concept of a written will was historically unknown. Instead of focusing on individual wealth, customary succession prioritizes the preservation of the family unit and the community. This is achieved through succession to status. Historically following the rule of male primogeniture, the eldest son steps into the deceased's social position. He gains control of the assets, but he also inherits the deceased's social responsibilities and debts. These systems clash. One prioritizes individual autonomy and the precise transfer of wealth, while the other prioritizes collective survival and inherited responsibility. The 1996 Constitution changed this by granting customary law equal legal status to common law for the first time. But that equality meant that customary rules now had to comply with the Bill of Rights. The landmark B case brought this to a head. The Constitutional Court struck down the rule of male primogeniture, ruling that excluding women from inheritance violated the right to equality. To resolve the remaining conflicts, Parliament passed the Reform of Customary Law of Succession Act, or the RCLSA. It acts as a bridge, applying the Intestate Succession Act to customary estates while adapting to traditional realities like the great and right-hand houses shown here. It legally recognizes partners in polygynous marriages as equal spouses and widens descendants to include accepted non-blood children. South Africa now operates under a unified dual framework. It protects the individual's freedom of testation while providing a safety net for those who die without a will, one that honors both Western and African legal.
When a person dies, their assets, debts, and legal responsibilities don't simply disappear. They have to go somewhere. The rules deciding exactly who gets what belong to a specific branch of private law, known as the law of succession. This diagram outlines three pipelines used to distribute an estate. A person can leave a valid will, known as testate succession. If they die without a will, the state steps in through intestate succession, or they can arrange the transfer beforehand through a contract. Applying these legal mechanisms in South Africa involves navigating a history of clashing cultures. Unlike most nations that operate under a single set of rules, South Africa utilizes a dual legal system. On one side is the common law, a framework that prioritizes an individual's freedom to write a will and transfer their personal wealth. On the other side is customary law. Here, the priority is the preservation of the broader family unit, ensuring a successor steps into the shoes of the deceased to assume their social status. To understand how these two different philosophies govern modern inheritances, we have to look at how the country's legal foundation was built and how it was fractured. In the 17th and 19th centuries, European powers imported Roman Dutch and English common law, imposing these structures while sidelining the indigenous customary laws already practiced across the region. By 1927, the government passed the Black Administration Act, institutionalizing a racially divided inheritance system. White citizens retained freedoms of common law to distribute their wealth. Black citizens were forced under a separate, rigid, codified version of customary law. A citizen's race dictated their posthumous rights, locking entire families into unequal economic futures. The adoption of the 1996 Constitution abolished that racial hierarchy, elevating both common law and customary law to equal status. This equality requires the master of the High Court to determine which system applies to a deceased person's estate, a process governed by choice of law rules. Generally, if a person drafts a valid will, common law applies. If they die intestate while maintaining traditional cultural affiliations, customary law takes over. However, treating these two distinct traditions as equals led to inevitable legal friction. The system faced a critical conflict. What happens when a rule of customary law violates the human rights guaranteed by the Constitution? This family tree illustrates the customary rule of male primogeniture. Under this tradition, the assets and status bypass the deceased's wife and daughters, transferring strictly to the eldest male relative. Because he inherits the entire estate, this rule frequently leaves widows and female children destitute. In 2004, the Constitutional Court heard the case of Bay v. Magistrate Kaialisha. The court ruled that male primogeniture violates the rights to equality and human dignity, officially striking the practice down. The Constitution stands as the supreme authority, protecting the practice of customary law while requiring it to align with the Bill of Rights. The Bay ruling did not erase customary law. Instead, it led to the reform of Customary Law of Succession Act, which harmonized these two traditions. This kinship diagram maps out how modern intestate rules now accommodate traditional African family structures, providing legal recognition for the great house and right-hand house in polygynous marriages. Today, all estates, regardless of race or culture, are administered under a single, unified legal framework. Ultimately, South Africa's succession laws represent a careful, deliberate balance between preserving cultural heritage and guaranteeing individual equality.